There are good arguments on both sides here. I've read the briefs thoroughly, considered the arguments. I am still skeptical on whether the Secretary of State's cross-claim could stand on its own. In other words, could the Secretary of State have brought this litigation against the ballot sponsors on his own? But I don't have to decide that issue because that's not what happened here. And as a practical matter, the issues raised by that cross-claim will be determined on the plaintiff's claims, whether or not the Secretary of State is allowed to bring the cross-claim. So what I'm going to do is I'm going to overrule the motion to dismiss. I also find that it does state a claim for relief, and leave the issue of whether the Secretary of State has standing up to the appellate courts to decide at a later date. I think it's more important that we focus our efforts here on the task at hand, which is to determine whether the factual issues on the ballot initiatives are such that will render those initiatives legally sufficient or insufficient. And so that's what I intend to do. Just to save some time, I have a proposal on amending or extending the progression order deadlines, and I will throw this out here to you, and then Ms. Hayes, you can tell me why I'm wrong. Here's what I'd like to do. The ballot sponsors, it's my understanding, are seeking to extend the progression order deadlines because the plaintiff and the Secretary of State have raised additional issues and concerns which were not the subject of the original pleadings, such as the circulator or notary malfeasance or fraud, as we've talked about extensively. I understand where you're coming from, but the court does have to be somewhat flexible in allowing the challenges to conform to the evidence as it is uncovered by investigation and discovery. And in other words, the court has to allow the plaintiff to amend the pleadings, not formally necessarily, but to conform to the evidence that is that comes to light. So this presents a problem for the defendant sponsors, and I understand that, because then it's kind of a moving target, and you don't know what to focus on, and you have very precious little time in which to proceed. So, and normally during the course of a regular litigation that's not expedited, the defendant has time to adjust to the evidence that's being discovered and proceed on those facts. But since this expedited procedure does not allow the defendants the time to do that, what I would propose is that we bifurcate the trial. We have in our statutes, Nebraska Revised Statute 32-1409, a provision that says that all signatures secured in a manner contrary to the provisions of the statutes shall not be counted. And then in the very next sentence, it says clerical and technical errors in a petition shall be disregarded if the forms herein prescribed are substantially followed. So, and we have kind of a burden shifting situation, and let me explain. I believe there will be some situations uncovered that may lead to signatures on a petition not being counted or thrown out. For instance, the situation in Hall County, where one of the circulators has admitted that he used the phone book and forged signatures on the petitions. Obviously, those signatures cannot be counted. But there may be other situations where, even if it is proven that the circulator of the petition engaged in fraud or the notary, the burden will be shifted to the defendant sponsors to prove the genuineness of the signatures on the petition. I'm getting that from Barkley versus Poole. If you read that case carefully, they are suggesting a burden shifting approach. So in other words, in some situations, even if the plaintiff proves that there was some sort of circulator or notary malfeasance or fraud, signatures may still be counted if the defendants can prove the genuineness of those signatures. So the court will have to make a determination factually as to whether the signatures on a particular petition simply can't be counted or whether they still can be counted if proven to be genuine. Barkley versus Poole says, in the absence of evidence of intentional fraud or guilty knowledge, the court needs to allow the ballot sponsors to prove the genuineness of the signatures on the petition. So what I would propose that we do is move forward with our timelines. And the plaintiff and Secretary of State, of course, have the initial burden of proof. That is, they have the burden of proving that the petitioner's petition signatures were secured in a manner contrary to the statutory requirements, and that these errors constitute intentional fraud and not merely technical or clerical errors. So if the plaintiff and the Secretary of State at our trial at the end of the month cannot meet their burden to prove that a sufficient number of signatures are invalid, that is, in an amount that would render the ballot initiatives legally insufficient, the case would stop there. The court would dismiss the case. If the plaintiff and the Secretary of State do prove that there are a number of signatures which were secured in a manner contrary to the statutory requirements in an amount which would render the petitions legally insufficient, then the court has to determine whether those irregularities are disqualifying or whether they merely shift the burden to the defendant sponsors to show the signatures are genuine. If the court determines that the issues themselves are so disqualifying that the petition signatures cannot be counted, according to Barkley, that means that there was intentional fraud or guilty knowledge, is what that case says. The court could direct a verdict after phase 1 of the trial for the plaintiff and the Secretary of State. If not, the court will then allow additional time for the defendant sponsors to meet their burden of proof to show that the signatures are in fact genuine. That may include an additional amount of discovery for both sides, and then a phase 2 of the trial at which the defendants would come forward and it would be their burden to prove that the signatures are nonetheless genuine. So obviously, if it's the latter situation and we have to proceed to phase 2, we're talking about going beyond the date of the election. I don't know whether we can help that at this point because the timeline is already extremely tight.